Take it away, Kevin.
Thanks, Nina. Thanks a lot. And welcome everybody to another great AIM webinar. This time we're going to be talking about how to align data retention and privacy requirements in one schedule. And this is an important topic because the world of data retention and data privacy are changing and colliding rapidly. In the next few years, companies and organizations of all kinds will have to contend with new and evolving privacy regulations, which will impact how we manage data. Organizations will have to be even more vigilant in understanding and improving the ways that they collect and protect customer data, while also finding creative ways to use that data and that information for business performance and competitive advantage. Well, let's just look at the picture the way it stands currently. Just on January 1st, only a few weeks ago, the California Privacy Rights Act and the Virginia Consumer Data Protection Act took effect. Later this year, Colorado, their Privacy Act, and the Connecticut Data Privacy Act will come into effect on July 1st, and the Utah Consumer Privacy Act will take effect on December 31st. And of course, there's any number of data privacy regulations around the world, and there are more on the way. What does all this mean for your organization, especially when these requirements may be in direct conflict with records retention requirements? We'll hear about that more today. How do we create a data retention policy in the face of all of this? And that's what we will be exploring today. In this webinar, we'll be joined by two leading data privacy and records management experts who will discuss how to privacy enable your records retention schedule. We'll dive into how to merge privacy and records requirements into one schedule, how to resolve privacy deletion and records retention conflicts, and how to establish a meaningful data retention schedule that really makes a difference. But before I introduce our guests today, I just want to say that we want to hear from you too. After all, we're a big community of experts and practitioners here, so I encourage everyone to join in. Please post your comments and your questions in the Q&A feature, and we will be working to get those into the Q&A portion of today's session. Well, with all of that said, I do want to introduce our guest experts today, starting with Mark Diamond, founder and CEO of Contour. Mark is a thought leader in proactive records and information management, litigation readiness, and risk compliance strategies. He and his company help bridge legal and compliance and security and business policies with effective processes, technology, and change management. Joining Mike is Carrie Child, a senior consultant at Contour. Carrie is also an expert in information governance and privacy. She has almost 20 years of information counsel experience leading the development and implementation of enterprise-wide privacy and information protection programs in a variety of industries. So, Mark, Carrie, welcome to the session today. Welcome aboard. Please tell us more about your advice and your perspective on how to align data retention and privacy requirements into one schedule.
Thank you very much, and good morning or good afternoon, or for me, it's good evening. And also want to welcome Carrie. Carrie, welcome today. This is a really interesting topic because rarely do we have the issue where organizations are focusing so much on trying to both meet records retention requirements as well as privacy. And on the surface of it, it looks like it's a little bit of a conflict. And we believe that almost every single organization is going to face this. Today, we're going to talk about how to do that. And we're going to jump right into this. We all know this, Carrie. We are seeing a lot of data minimization going on right now. And this was something that wasn't happening a lot previously, but the activity has picked up, and particularly the regulatory activity.
Absolutely. So this is now old news. This is from September of last year. The French Supervisory Authority, CNIL, fined a group 250,000 euros in part because they failed to comply with the EU obligation to minimize data. So data minimization is a concept that you have to get rid of data when it's no longer useful. So every privacy law in the world has a requirement that says that you can only use personal information for the purpose for which it was collected and for no other purpose. We've not seen enforcement of those two until recently. So you have fine from the French supervisory authority has been active.
Carrie, I think we're gonna,
this
Carrie,
is,
we're
this
losing a
is
little bit of audio
now
on you.
becoming,
Yeah, Mark, I think Carrie is breaking up. Can you maybe
Yeah,
jump in and take over a bit while we troubleshoot that in the back
why don't we do that?
end?
So essentially, I'm not gonna do as intelligently as Carrie does it, but essentially, a number of regulators are beginning. This is not a Facebook problem. This is not a Google problem. A lot of regulators are really getting down on organizations to say, you have too much personal information that you're retaining much too long, and we're seeing some fairly significant issues around that and some significant fines. And it's not just the big folks, it's the little folks. And it seems like every week now we have another organization that's jumping out to do that. But here's the problem. Okay, you're a in-house counsel, your privacy counsel, your privacy group, and you say, I get it. We have to go out there and delete a lot of our personal information. We can't retain it longer than an express business purpose. And so privacy goes, they reach out to IT and says, hey, we got to delete this personal information. And IT then reaches out to legal saying, sure, what's our policy? And legal brings in records management, and records management says, well, some of the stuff you want to delete personal information, we have records retention requirements. We can't delete it. The rules say we have to keep it. And the privacy folks say, no, the rules say we have to delete it. Meanwhile, the business units chirp in and say, hey, I need this. I mean, you're talking about going after my data warehouse. You're talking about this other information that we need. I mean, do you really know we have to delete it? Because I've talked to my friends at other companies, they haven't done that. So the organization creates a committee, and the committee's formed, and then the committee meets, and then the committee meets, and the committee meets, and the committee meets. And this is not a new scenario. If you've been in the world of records retention, maybe you've been through this many times before, but we are either re-experiencing or revisiting this same conversation, but now more complex, because it's not only about the tussle between the business units and the records manager. Now it's the tussle between the records management, the privacy folks, and the business units, which is making it more complicated. And Carrie, I'm going to check in to see how we're doing on the audio part of it.
So I've killed my video. Hopefully that will help. Is that better? Okay.
Yes.
Sorry about that.
And Carrie,
thank you everybody for being
before.
so patient. So Mark, you laid it out perfectly. This is a situation where each of the bits of the organization want to do the right thing, but everybody is confused, and also they want to make sure that business can do what business needs to do. So now what do we do? So here we go. We've seen a lot of clients come in and say that they need a new data retention policy. And, they may be organizations that have an existing records retention policy and schedule, but they need a data retention policy because they need to talk about legal and regulatory retention and disposition requirements and business value of personal information. And we're going to talk about the fact we think that you already have this, that a records retention policy and schedule already talks about legal and regulatory retention requirements and business value. So the only thing that's missing is personal information. And we're going to show you how we think that you can accomplish that.
And I'll just add into this. We think we see sometimes it's the privacy groups on their own volition saying, create a data retention policy. And they may not announce it, may just have it. But we believe fundamentally it's a bad idea to have both a data retention policy and a records retention schedule. But Carrie, walk us through. Here's the issue. We've got this conflict, and here's an actual example of the conflict between records retention and data privacy. Walk us through this.
Yeah, so as Mark's just said, the privacy comes up and says, nope, we need a data retention policy because we can't keep this information any longer than is reasonably necessary for the purpose for which we collect it, right? So you have a law, and here I've used the California example because it's helpful. You have a law in the government code that says you have to keep applicant records for some period of time. And then for become employment records, but you have to keep them 4 years after the records or files are initially created and received, or 4 years after the date of the employment action taken. And many organizations are going to say that is we're going to keep them 6 years.
I will pick up here. Carrie, you're breaking up.
Yeah, Mark, if you wouldn't mind
Yeah,
kind
I'll
of taking,
to keep that employment
over a bit
information
here.
for whether
Carrie is
it's
breaking up pretty bad. Let's go ahead and have
Yeah,
Mark
yeah.
take over while we troubleshoot that in the background. All right, Mark?
Murphy's Law
Thank
of
you. Yeah.
how many years ago? Well, we did that. So
Right.
essentially, and I'm going to summarize this a little bit, is that the California government code says for personal information, you got to keep it 4 years. And a lot of organizations are regionally keeping 6 or 7 years, and there's a more detailed conversation why you want to keep it longer. But at the same time, if you look at another part of the code, they're saying personal information, sensitive information, including this application's personal membership and other information, can no longer than reasonably necessary for the disclosed purpose. And so how do we balance this conflict? It sort of feels like, no, it's, we got to get rid of it right away. And then the records folks are saying, no, we need to keep it longer out there. And so here's, and this is sort of the crux of our issue. We're seeing this collision between the privacy and the records retention. And by the way, for those of us in the compliance world, surprise, surprise, we have rules that are not consistent, that are non-prescriptive, or actually have a conflict associated with them. And by oftentimes these conflicts get worked out through case law over many years. But here we don't have the time to wait 3 or 4 years to figure out how the case law resolves this. We have to make some decisions now because companies are being fined for too much personal information, and other companies are being fined. And this major financial services fines went around last year for not saving records management, hundreds of millions of dollars of fines out there. And so we have to be able to work our way through the collision on this and figure out how do we do this. And so first we're going to say is that organizations need to have a hybrid of a data retention policy and a records retention schedule. We believe this is the new best practice. This new updated policy should include legal and regulatory retention requirements, should include business value, but also should list which of our records have personal information and add what is the legitimate business need associated with this. This is a big step. I mean, records retention schedules, and you could argue, I'd probably argue this, some haven't changed a lot in their fundamental form in the last 20 or 30 years. We see now a fundamental change in records retention schedules / data retention policies. One note, we don't care if you call it a data retention policy. You shouldn't care if you call it a data retention policy. We don't care if we call it a record retention schedule, policy and schedule. We don't care if you call it a potato. It really doesn't make a difference. It's the same thing. If you have separate policies that actually don't work through these conflicts, that don't figure out how we manage through them, you will be non-compliant. And we're seeing some very large corporations that in many cases, because why is this? Because sometimes the privacy group doesn't talk to the records group, and maybe they do or don't talk to IT out there. This is a big deal. As Carrie alluded to out there, many organizations already have the records retention schedule as a baseline. So you don't have to reinvent the wheel. We just need to make some updates as part of it. The question comes up, does that mean we can only store personal information, the maximum time we can store personal information is the legally required record retention period. In this example, if a regulatory requirement says you need to save this record for 6 years, and this record has personal information out there, does that mean the max we can save it is 6 years? Well, no. Actually, we can save it longer than that based on a reasonable business justification. Does that mean because now we can do a reasonable business justification, we can keep it for 12 years? No, actually, we can't keep it that much longer. There is a Goldilocks middle zone of how long you can save personal information. But here's the tricky part. You have to have a business justification. And we believe it's important to document that business justification. Well, we don't believe, actually, the laws say this. This business justification is something that is you have to document to be able to do that, because at some point, sometime, you may have a regulator coming out saying, why are you retaining this personal information and what's the reason associated with that? How do you go through this personal information business justification process? Well, one way of doing it is going to your records retention schedule. Doesn't contain personal information. Is the business value of the record longer than the retention period, the legally and regulatory required record retention period of the personal information? Well, we're going to save this for 7 years. Is this reasonable? And is this in line with business purpose for which is collected? And if so, can you go and document that? What are some examples of this? Carrie always likes to talk about, there's some cases where you may need to save warranty information for a very long time. If you're driving a car, you may be driving that car for 30 or 35 or 40 years. It happens. And at some point, even 30 years down the road, the auto manufacturer may have a need to contact you to announce a recall. I mean, that's what the laws say. So if you're a car maker and you're saying, listen, I need to keep everybody's registration information, everybody about our car, and I'm going to keep this a very long time, even though it contains personal information, because I need to know that Mark is driving a Volvo and this is the kind of car. So if I ever need to get a hold of Mark, I could do that. In that case, I would say that's a reasonable justification. Now, suppose you are, making a toaster, or let me say a other type of consumer device that doesn't last very long, trash compactor. Do you need to say that for 25 years? That becomes less and less defensible. And so there's a whole business justification process that organizations should go through. And this, we believe, here's an example, privacy-enabled records retention schedule. Here's the record. Here's a description. Here's examples. We're all familiar with that. We've been doing that for years. Here's the retention period, permanent. Oh, and by the way, this has personal information. In this one, we're talking about formal corporate board of director documentation associated with the board of directors notices and minutes and other information. And that has lots of personal information about shareholders, board members, personal information, other things like that. And here is the critical part. This is why we're going to save it. We work in these states, and this is required, and this is what we need to do. Fine. In this case, we would argue that permanent retention of personal information has been properly justified. Now, here's the challenge, is that there are, as we speak today, there are no bright line rules. There's nobody that says, well, if it's warranty, you can keep it this long. If it's this type of personal information, you can keep it this long. You have to use a reasonable judgment to be able to do this, and use your reasonable judgment for putting personal information. And this begins to move into the world, as we're seeing more commonly, away from just the world of records management into the larger world of information governance. And so increasingly, we're seeing organizations that are putting together, updating their data security classification policy, figuring out what record types out there, linking those to data maps out there, putting that in a system, and applying what we call the 5-second rule, which means somebody needs to be able to apply all these policies within 5 seconds out there. What this heralds is, and part of the theme of what we're talking about today, is no longer can records management live in its own silo. No longer can or should privacy live in its own silo. We've known for years legal hold processes should not live in their own silos out there. We really have to start thinking about an integrated approach, and the integrated approach applies both at the policy level, which is what we talked about, as well as at the execution level. And if you have separate execution processes for records retention, and you have a separate execution process for privacy and a separate one for all these, it's going to be much more difficult for anybody. And quite frankly, you won't be successful. And so we are seeing many organizations that are beginning to rethink their overall strategy and what they're doing. Carrie, are you, it sounds like you've got your audio fixed. Let's hope, knock on wood.
Well, sort of. I've actually had to dial in on my telephone because that is where we are right now, folks. I apologize. Thank you all so much for being so patient with the audio. I hope this is better.
Yep, you're perfect. You're great.
Awesome. Love that.
And you're just in time for the tough part. I did the slides. I'll give you the tough questions, Carrie, if that's okay.
Okay, so I do have to say that I was listening to you do the slides. And you did a wonderful job. You don't even need me.
We won't go there because that is definitely not true. And I just want to conclude, what we've talked about in the last example was application of semi-structured and non-structured data. And again, a lot of organizations using, for example, Microsoft 365 to be able to do that. Your database systems are a little bit different, but the same rules apply. Just because something's in a database, we have to apply records retention rules, and we also have data privacy rules. And we have to, or personal information rules for privacy requirements, and we have to apply them consistently. And part of the reason we want to include this in here is that we're seeing lots of organizations who have a data warehouse, and Carrie, I'll give this to you. Are data warehouses in scope? Setup question.
Right. Probably yes. So we've seen there were a lot of organizations that were trying to work through all of these questions with respect to how to comply with GDPR, et cetera. And what we've seen is that while we as, business people have questions about whether, the data warehouse isn't really a business tool, we're using it for analytics. Regulators are very clear that data warehouses, data lakes, if you can associate it with a person, with a human, then it's personal information, and it's still going to be personal information. So there are ways to address that, but yeah, you need to be thinking about what's going to happen with this data that I've got sitting in my, Hadoop platform for the last 15 years.
And I worry about it because, that's critical information for marketing folks, but a lot of it is polluted. Sometimes you can't necessarily easily delete it, or you can't necessarily de-identify it. That's a hard problem. But we're worried because again, the rules apply to that. All right, we're about ready to go into the Q&A question. Just real briefly about us. Contoro, largest independent provider of information governance and privacy consulting services. We don't sell any products. We don't store any documents. We do more of this than anybody. We work with more than 30% of the Fortune 500 on all aspects of information governance and privacy, really helping organizations get to the end state. And we've got many resources on this exact topic, including this white paper. Email us, info@contoro.com for the white paper. And that talks about this particular topic in more detail, as well as a significant amount of other content. And so I want to make sure that we can save the bulk of this presentation for questions out there, because I know this is something that a lot of organizations struggle with. So let's go into the question and answer period.
Very good. Thank you, Mark. That is Mark Diamond from Contoro, and joined by Carrie Child. Carrie, the persistent and intrepid
Yeah,
guest
sorry
as
about
well
that.
today. Thank you both for your comments today. Yes, let's open it up for some questions now from our attendees today. Let's take this time to our advantage with these two experts. We are getting some questions in here, and I want to just take them a little bit in order, I guess. Naomi was the first to chime in earlier and just ask the question, are there differences between business and government in a city, for example?
Terry?
So, yeah, it's a great question. And the answer is going to depend on how your state responds to some of this. So in some states, the state legislature has passed laws that say that our state government is also responsible for protecting the information about residents of this state. And so that information those requirements apply. In other states that hasn't been the case. But I think that it's really important, all states, and particularly at the federal level, have laws that address how government entities can use personal information of the residents, citizens, whatever. And so while this may not be quite so mandatory for a government entity, I think it's absolutely beneficial. And if you are a government entity that has, maybe you're a school, like a state institution of higher education, and so you do have people who are coming to your institution of higher education from overseas, they are going to be expecting that those laws will apply. So I think it's beneficial to walk through this process regardless of the kind of entity that you are. But I can understand that if you are a government entity, there's maybe a little bit less burning need to do this.
Well, be careful. Just remember, modern privacy was created in the aftermath of World War II and the misuse of personal information by the Nazis.
Exactly.
That's a huge issue. And you may be exempt today. You may say, oh, gosh, I'm in California, thank goodness. I wouldn't make that a long-term strategy.
Absolutely.
Because, and remember, the original breach laws were started from a breach in California, because the employee database was breached. And so in the case of the breach law, they from day one included that. So again, you may not have exactly the same, as Carrie said, the exact same timeframes as some of the commercial side of the house, but your strategy should, it's coming. In my opinion, it's coming.
No, I think that's right. And just for fun historical facts, all privacy laws are based on the Fair Information Practice Principles, which were drafted out of a report coming from the United States Department of Health, Education, and Welfare in 1973. So you're a government entity. You may not have quite the same time frame, but Mark is exactly right. It's coming for you eventually. Don't put it off.
And I know there are a number of international attendees on this call. I'm actually international myself as we speak. We're talking about general privacy principles here, and unless it applies whether GDPR or Canada or wherever you may be. And so don't think, well, we're different here. No, actually, we think these principles are going to apply pretty much across the board.
All right. Well, we do have some more questions coming in. This one from Donda. Thank you, Donda, for your question today. Donda says, I also see legal holds being another element to address in this conversation. Legal departments are famous for not releasing holds in a timely manner or at all.
No.
This significantly impacts the ability to dispose of information, even if a schedule has the business privacy and regulatory justifications documented. What would you recommend to address this issue?
And there's two questions here. The first question, and it's a great question, by the way, thank you. The first question is, if I have a legal hold, does that trump my, I get either a subject access request and a request to erasure or a deletion request. And so if I'm under legal hold and somebody wants to, am I forced to delete the personal information at that point? And after the case is adjudicated, can I get in trouble for keeping a legal hold that contains personal information long after it had been released? Carrie, I'm good at summarizing. I'll give that for you to answer.
So thanks for the hard one, Mark. So I think in the U.S., this question is much easier to answer. In the US, your obligation as an entity to hold information for which you reasonably anticipate litigation or for which litigation has been filed is absolute. You must hold information if you reasonably anticipate litigation. Now,
So the
whether
hold
you're
trumps, in that case, the hold
trumps
trumps.
everything else.
Okay.
And now, whether you're over retaining or not is a separate question between you and your legal department. That's not the subject of this conversation. In other countries, in places other than the United States, including if it's cross-border litigation, there's a little bit more of a discussion that has to happen. The US has a federal law called the Cloud Act, which is specifically intended to help address some of this. Whether it does or not is also a separate question. But irrespective of that, it is important that the ability of an organization to properly respond to litigation, and also the legal obligation of an organization to provide information and discovery, is so critical to the function of justice that in most cases a legal hold is going to trump many other things. And the privacy laws that we've been talking about all have an exception for, legal responsibilities, legal process, legal justifications, right? So probably in most cases, your legal hold while that litigation is active and going on is going to trump anything else.
What about legal
yeah.
holds that go on? Hey, we've kept this on for 15 years, even though that case was settled 8 years ago.
Right. Yeah, I have no idea who we could possibly be talking about. That never happens. So in that instance, that's really a bigger question, because yes, it's true that the legal department isn't always great about releasing holds, because it's so much harder to tell when something is over and done with. I mean, unless it goes to the Supreme Court, and then you know that it's difficult to say we don't need this anymore. Plus, all legal departments are pack rats inherently and by their nature. So they want to hold on to everything. From a purely regulatory perspective, it's probably, if it's still on hold because the legal department hasn't released the hold, you can probably still say, well, it's still on hold. Our legal department hasn't released the hold. But I think that the further away from the actual litigation you get, the harder that is for a regulator to swallow, and creates problems. So this is probably an opportunity not only for you to create a privacy-enabled records retention schedule, but also to work with your legal teams to be more not proactive, but more timely about releasing legal holds in order to be able to comply with lots of other obligations.
All right, Carrie and Mark, we have a ton of questions coming in, so I want to keep this moving. Thank you so much for your comments today and your questions for our guest today. This one coming in from Sarah. Sarah says, one of my biggest questions is understanding rule applicability with all of these individual state rules and the globalization of the workforce, people working from home in various states and so forth. What is an easy way to track which of the privacy rules we need to follow?
Well, there's
get a privacy program.
yeah, get a program. Let me try this one. So don't worry too much about the individual details. When you create a privacy program, think about privacy agility. Think about, I know what my personal information is. I know how to maintain it securely, store it. I know how to get it back. Hey, by the way, sounds a little bit like records management. I know how to delete it when I need to. We strongly recommend that most organizations build a global privacy program and then have local exceptions necessary. If you put the core capabilities, a well-designed privacy program will work for most, if not nearly all, the different privacy regimes out there. And if you can do that, that will get you much further along. What you don't want to do is do analysis by paralysis. And we've seen this before. You invite in a law firm and they say, well, we have this one and we have this one and they have this one and this one, and they have all this level of detail. And they think that if they boil the ocean, somehow, and they never get executed. And so be
Yeah.
smart about it. And create an overall, again, we talk about information agility, privacy agility, then you can make the exceptions necessary. But if you do that, it's not going to be as hard as it may feel like it is right now.
Absolutely. So the crack I made about the FIPS earlier was actually in service of this very question. If you look at all of the privacy laws across the globe, they all have at their core basic standards of the fair information privacy principles. So if you are, and then there are usually requirements layered on top. So, the right of a data subject to make a request about their information, et cetera. So if you put into place a program that addresses all of the requirements, you've got all of your core stuff in there, including some additional things like incident response and records management, data classification, then you have a program that can absolutely handle all of your requirements globally and then just be tweaked as necessary for each of the individual requirements or states or countries that have weird specificity to them. It is not possible to create a privacy program that is compliant with California and then reinvent it to comply with Virginia and then reinvent it to comply with GDPR. You're going to lose your mind if you try to do that. You have a privacy program that does what you need it to do at its core, and then you're able to tweak it around the edges.
All right. Next question, Kevin, fire away.
We have a ton more questions, guys. So
I'll
we're
be
going to
faster,
try to
I
get to
promise.
all of the questions here today. If we don't, we will certainly be putting people in touch so that the conversation can continue. But this one, Laura has been waiting patiently. Laura asks, since applying the regs to existing data may be onerous, does the creation of a robust going forward management policy and process give you the appearance of being in good faith and result in some grace from regulatory bodies?
Well, the short answer is going to be yes. And I want to be a qualified yes on that. There's a fear sometimes that if you create a policy, you create a program, that if the regulators come in the very next day, well, you haven't done it. Well, no, because I've just started halfway through it. The regulators, first and foremost, they're going to want to see you have a plan. Next, they're going to want to see you be able to execute the plan. There won't necessarily be an expectation that you have 100% of your plan completed. If your strategy, and Laura's exactly right on this, if your strategy, and we agree with this, is let's hit the go forward stuff first, let's get that tamed and control, and then we'll go back and look at the legacy data. And somewhere between that, a regulator comes in, hey, I'm trying to do the right thing, it's defensible, we're ready to move forward. You can't be perfect on that. And at least in our experience, we really haven't seen organizations gotten in trouble that have been able to demonstrate a plan, that they're trying to do the right thing, and it's a question of execution. Now, that doesn't mean it can take 10 years to execute your plan. There's a reasonableness part of this, but they want to see some forward progress.
This question from Bill: how do you see disputes between consumers and organizations being resolved, especially when the retention requirement does not specify a specific time frame and the state is without a uniform preservation statute?
Oh, that's a great question. I think it is important to be able to, and Mark just laid this out perfectly. You can take this for all of the answers going forward. Have a plan and be executing on your plan. And at that point, you have a good story to tell to the regulators. So even though, because all of these laws say no longer than necessary for the purpose for which it was collected, and they don't have a specific retention period on them, because they can't, because there are lots of other reasons you have to keep personal information, have that conversation, be able to describe why the information is being retained for X period instead of something shorter than that. We don't know. All of the regulatory action that has taken place up till now has been on organizations that have no retention and disposition process. So we don't know what it looks like if a regulator disagrees with the length of time that you're retaining things. but you are ultimately getting rid of them. We haven't seen that yet. We don't know what that looks like. So we can assume for right now, for these purposes, that if you are behaving in good faith, you're doing what you say that you're going to do, you're just keeping it for some period of time that that a consumer may feel is too long. We believe that you are still able to, reasonably make that argument, and that will be acceptable. And and even if it's not, the conversation with the regulator goes better because you're trying to do something instead of not doing anything.
What if the data is in aggregate for something like credit risk modeling, not individualized?
Well, this goes back to our data warehouse issue. Gary, I don't know if you want to finish that, but
Sure.
no, you have your responsibility. It's aggregated. No, I mean, you have to deal with it.
Well, and so if it is truly aggregate data, then it isn't personal. However, if it is in a data warehouse, so you can create aggregate data from it, but it is still personally identifiable or personal information in that data warehouse, in order to create the modeling, that data warehouse is still personal, even if the modeling itself is aggregate data. So you have to be really careful. Be very clear that any information that can be traced back to a person is going to be personally identifiable information, personal information. But if it is truly aggregate, if it is truly fully de-identified, then it's not personal data and none of this conversation applies.
How do we prove the data was removed, or do we need to prove that the data was removed, personal information?
Depends on what you think you need to prove and why. For the various laws, there's usually some sort of record keeping requirement that you have to keep a record of the response. If a data subject exercises their rights, you have to keep a record of the fact that you responded to that, and you are authorized to keep the limited personal information you need in order to be able to show that you responded to their request. But beyond that, deleting your information should just be part of your regular business process. So if you just keep your regular business records about your regular business process about deleting data because it has exceeded its retention period and it wasn't on hold or being maintained for any other purpose, that's your proof. Is regular standard business process.
Gary, let me see if I can summarize this. If I call up Titleist for golf balls and say, hey, delete Mark Diamond's personal information, and they say, okay, thank you very much. Hopefully they're not on this webinar. Delete this personal information. They're going to have to keep a record saying, hey, we deleted Mark Diamond's personal information. And it's a little bit of a, well, we still have Mark Diamond's name because we have in the record that deleted his personal information. That's acceptable. If on an ongoing basis, Mark Diamond says, delete my personal information, and they say, Mark who? You don't have to have a record that a year ago you deleted Mark Diamond's personal information, because at that point you didn't have it. So it's again, it's trying to do the right thing. And yes, record keeping around subject access requests and specific requests for erasure. Otherwise, it's an ongoing business process. And by the way, I would hate to see you get caught up worrying about how to document this exactly versus going to execution mode.
Right.
Because we've talked many times, there's going to be a tremendous amount of gray areas and non-prescriptive nature on this. Don't let that stop you from doing the right thing.
All right, that is Mark Diamond and Carrie Child from Contoural. Thank you, Mark. Thank you, Carrie, for being with us and helping us understand how to align data and retention and privacy requirements. At this point, I'd like to take it back to Nina to close us out today. Now, Nina, I know that the 2023 Industry Watch Report is underway, and we'd like everyone to be part of the research, and the research window is closing soon. So tell us more, Nina.
Absolutely. So AIIM's 2023 Industry Watch Report is currently in motion. The annual State of Information Management Survey is live, and we'd love for you to take it. Results from the survey will be the driving force behind this year's Industry Watch Report, and the survey closes this Friday. So send us your feedback soon. Everyone who completes the survey will also be automatically entered for a chance to win a $100 Amazon gift card. So survey participants will also receive a copy of the report once it's published. The link for completing the survey is in the chat, and some of the findings will be shared during AIIM's 2023 conference in New Orleans. Speaking of conferences, AIIM is headed to New Orleans and promises to be a conference unlike any other you've ever experienced. This year's theme is content in the flow of work, and the conference curriculum provides you with a comprehensive and proven methodology for mastering your organization's content to operate more effectively. Register now, you won't want to miss it. This link is also in the chat. As we bring this webinar to a close, just a few last-minute reminders. We've recorded this webinar, so you can catch anything you want to hear again in a recap email that will be sent within 24 hours. A link to the resources for this webinar was put in the chat. You'll find a copy of this presentation, as well as additional resources through that link. Don't forget to take our feedback survey and let us know how we did. A big thank you to our contributor, Contoro, for a wonderful, informative webinar. Now, before we go, I'd like to ask Mark if he has any last-minute key takeaways for our audience.
Yeah, the key takeaway that I'm going to give is that we have to be smart about this, and we're going into a new area. There's a tremendous opportunity for information governance experts that can figure this out and can be flexible and smart, and it's a skill that you already have. We just need to make more of it. And I think there'll be a lot of trouble for organizations that get stalled out or want to hold on to very traditional approaches or just can't move forward. So, you know, a tale of two careers here. And I wish everybody really success in terms of moving that. And by the way, if we didn't answer your question, feel free to email us, info@control.com. Happy to get on the phone with you. And I know there's lots of questions. Sorry about that.
Absolutely. And Carrie, what about you? Any last-minute feedback for our audience?
Yeah, I think the thing that I would just want to leave everybody with is please do not let perfect be the enemy of sufficient. Mark's exactly right. Get started, and you will start to feel the rhythm of what needs to happen. But go ahead and get started. Don't get paralyzed and with fear. Just get started.
And start with getting the right kind of records retention schedule. I'll just add that in.
Absolutely. And what about you, Kevin?
Well, this conversation has been great and a bit eye-opening. It's really indicative of the way things are changing culturally as well. I mean, privacy is something that, you know, in my time, we didn't think the same way about data privacy as we do today, and the implications weren't as big, not only in terms of security and compliance, but also in using information in ways that can improve the performance of the organization. And where is that fine line, and how should we straddle that fine line between privacy and using information as an asset? And as these regulations and expectations keep changing, it's really important to have these kinds of conversations with these kinds of experts so that we can do the right things in building a policy that makes sense on all fronts.
Absolutely. Thanks again, everyone, for joining us today. This is Nina from AIIM saying, see you next time.